Okay, Idamik Skanatani, Nidaniko Sakwaving. It is my pleasure for me to be your host today. My name is Dr. Lana Potts, and today we are starting part one of our four-part series around our training about cultural safety and inclusiveness. We will be presenting Stuart Wutke, and our topic today is talking about the settlement agreement. Also really important on the screen is just some information about the claim. There's you'll see throughout the claim just where to link and where to get more information about this. The information that we're sharing today is a part of a training. It's really used for general purposes and does not represent the opinions of Deloitte. Deloitte is not providing advice or services by sharing this information, and it is important to seek advice or services before making any decisions on any actions that may impact class members or individuals. Deloitte will not be held responsible for any actions taken based on this webinar or web page. So you can get in contact regarding any claim-specific questions. The information is on the screen. There is a number 1-833-852-0755, and then also either email generalinfo@contact.fnchildclaims.ca, and we will be also sharing that information at the end. We can go to the next slide. Over the next few days, we're going to be talking a lot about some topics. And I've stated before, although this is the lived history of First Nations and Inuit and Métis people, can be very triggering for individuals. It can bring up personal experience, past traumas, and it even evoke very strong emotions. So please be aware of that, just to take some self-care if you need to step away or if you need to come back. There also is a couple of sites that we're going to list as resources. These are free mental health crisis support for class members. These are available 24/7 through the Hope for Wellness, and you can contact the Hope for Wellness by telephone at 1-855-242-3310, and this is toll free. They also have an online chat, which is at hopeforwellness.ca. And counseling is available in multiple languages, including not only English and French, but Cree and Ojibwe. And so there also is one for children. This is Kids Help Phone, and Kids Help Phone is also 24/7, 365, and their number is 1-800-668-6868. And you can also text that number as well at 686-868. A lot of eights this morning, but very important to be aware around listening and to take care of yourself first. You can go to the next slide. So I put this training together. I will take a little bit of ownership here, and this is a part of one of four. So this is part one of four training sessions that actually are looking at preparing individuals to understand why we're here. That was a statement that I made a while ago to say, why are we here and what do we want people to understand about how we got here? I always believe that where we come from is a great indicator of where we need to be and what we need to know. And so we're going to start today with an introduction to the settlement agreement. So understanding what is the settlement agreement? We hear about the claims, we hear about the word, but really giving a good history and background. And this is with our expert, Dr. Stuart, with Stuart Wutke. We go into sessions 2, 3, and 4 throughout the week, and we'll talk about colonization, we'll talk about child welfare, child removal histories, and then looking at the Indigenous cultural context and how that actually plays into leading into children who were removed from care. So a little bit about myself. So my name is Dr. Lana Potts. I am from the Beginning Nation in what you know as Southern Alberta. I was born and raised there and very proud to be living and working there as a physician. I also work as a director with Deloitte and within nation building. I was raised by my grandmother and my mother. My mother's name was Stripe Coopstick, and I'm very proud to say that I learned a lot of ways around working with community and being inclusive as a part of growing up as a ceremonialist. I have a lot of expert and passion, I think, within this around helping children and helping people. And I really believe that the more we do together and the more we learn, the more empowered we are and the more we actually create a brighter future for our children. So we can go to the next slide. So our speaker today is Stuart Wetke, and Stuart Wetke is a member of the Garden Hill First Nation in Treaty 5 in Manitoba and is a leader in Indigenous rights and policy reform. Mr. Wetke has been pivotal to the developmental of rights-based federal legislation, such as the new Child and Family Services legislation. And as general counsel at the AFN, Mr. Wetke has successfully advanced many large class action settlements and has been a significant contributor on the advancement of reconciliation in Canada. It is our pleasure today to have for you Mr. Stuart Wetke. Thank you for joining us today.
Thank you. Good morning, everyone. As mentioned, my name is Stuart Wetke. I'm General Counsel with the Assembly of First Nations. I've been involved in this child welfare litigation for a number of years now, and it's my pleasure today to give you some background information on how we got to formalizing the settlement agreement and making compensation available to many of those individuals that were impacted by Canada's discrimination. If you go to the next slide. So as I mentioned, the Assembly First Nations is a main party in the litigation for the Canadian Human Rights Tribunal on Canada's discrimination in child welfare and Jordan's Principle. And also at the, we've initiated a settlement, we initiated a class action regarding Canada's discrimination as well. And there was a lot of work put into AFN's involvement over the years and sort of how we got here. Litigation in the end was necessary, as all attempts for policy and political solution to the discrimination weren't very successful with Canada over the years. Next slide. So as I mentioned, the AFN has been working on child welfare reform for a number of years. The First Nation Child Family Services Program was initially released by Canada or initiated back in 1990. And it was clear from the beginning that there were a number of issues related to the federal program itself. Between 1999 and 2000, the AFN worked with a number of experts across Canada, including the First Nation Child Family Caring Society of Canada, and looking at various problems with the programs itself. We developed a national policy review, which was a report on the effectiveness of the program and where there were shortcomings. Canada at that time was not convinced and requested further research be done. And again, additional work was done between INAC, the AFN, and various experts between 2001 and 2005, which resulted in the Wenday reports, which were released in 2005. And the reports themselves highlighted a number of deficiencies in the program and how children were being adversely impacted by the program itself. In 2006, the AFN developed a leadership action plan on child welfare as a further attempt to try to get policy reform and changes within the bureaucracy. By 2007, there was no action forthcoming by the federal government. Next slide. So the evidence that came out in the joint research that the AFN, Caring Society, and others in Canada undertook really highlighted the fact that there was inequitable funding between services that First Nation agencies were providing when compared to those services provided by the provinces. So essentially, the findings were that roughly First Nation agencies were receiving 22% less funding than their provincial counterparts. It had an adverse or perverse incentive in that funding to remove a child was unlimited under the program. However, there was no or very limited funding with respect to least disruptive measures. Essentially, there was very little money or none available to keep a child in the home where agencies could work with the parents and address any concerns they had. So essentially, the perverse incentive was that agencies couldn't get funding unless they actually apprehended the child. With respect to Jordan's principles and other programs itself, there was obviously jurisdictional disputes on who had responsibility for various children and families, whether they're on reserve or off reserve. So that's essentially what came out of the Wenday reports, highlighting the number of problems with the program itself. Next slide. This slide sort of represents the number of studies, research, reports that were developed by not only the AFN, but by the House of Commons, the Senate, the Auditor General, over a 24-year period. And essentially, we note that since the work that we've done on the National Policy Review in 2000, a whole slew of activity took place highlighting various problems with the First Nation Child Family Services program. Next slide. What's important to know, despite all of that, Canada had chosen not to amend or fix its program in any meaningful way. So this led to the Canadian Human Rights Tribunal process. In 2007, after it became evident that Canada was unwilling to fix the problems associated with the First Nation Child Family Services program, the then National Chief Phil Fontaine instructed the AFN to file a human rights complaint alleging Canada's discrimination against First Nation children and families. Next slide. So we filed a joint complaint between the AFN and the First Nation Child Family Caring Society back in 2007. There were a number of procedural hurdles we had to get over that Canada put in front of us, but eventually in 2014, we were able to begin the hearing into the discrimination before the Canadian Human Rights Tribunal. In 2016, the Canadian Human Rights Tribunal did make its ruling, and they found that Canada was discriminating against First Nations children and family in both the First Nation CFS program and its implementation of Jordan's principle. The tribunal also found that the discrimination that occurred to First Nation children and family was one of the worst kind that they've seen. Moving forward, a number of years after the main decision came out, the Assembly First Nations did request for compensation to be paid to all the victims of Canada's discrimination. The First Nation, I should say the AFN, was the only party in the Human Rights Tribunal process to seek compensation to be paid directly to individuals to compensate them for their harms. Other parties before the Human Rights Tribunal took different approaches, but in the end, the Canadian Human Rights Tribunal sided with the AFN and found that discrimination had occurred in the worst form and that children and families were entitled to compensation. Next slide. So under the compensation order and decision by the Human Rights Tribunal, essentially they found that discrimination occurred and Canada was ordered to pay compensation. The AFN asked for the maximum amount to be paid under both Sections 52(3)(e) of the Canadian Human Rights Act and Section 53(3). Essentially, Canada was required to pay $20,000 in compensation for general pain and suffering, and an additional compensation in the amount of $20,000 for willful and reckless conduct. The tribunal noted that Canada had all this evidence before them and various reports highlighting the various problems, but really was looking after their bottom line as opposed to providing proper services to First Nations children and family. And they found that that conduct warranted the maximum amount that was available under the Canadian Human Rights Act in the amount of $40,000 combined. Next slide. So the tribunal have made an order essentially stating that First Nations children living on reserve in the Yukon who were unnecessarily apprehended and placed in care outside of their homes, families, and communities were entitled to compensation, as well as the First Nations parents or the caregiving grandparents of that child. Now, it's important to note, under the tribunal's orders, there was a three-part test. In order for someone to get compensation or to become eligible for compensation, they had to be removed from their home, their family, and community. They had to meet all three criteria. Next slide. With respect to the other class, the Jordan's Principle class, the tribunal noted that those individuals that were entitled to compensation were those children who were basically unable to obtain essential services or experienced gaps and delays, or even a denial of services under Jordan's Principle. And it also included those children that were not removed from the home, basically that they still remained with their parents, but were still denied services. Next slide. So the tribunal also had limited jurisdiction under the Canadian Human Rights Act on who would be entitled to compensation. So even though the program had started in 1991, those individuals entitled to compensation under the CHRT process were anyone that was removed between January 1st, 2006 and March 31st, 2022. For the Jordan's Principle class, they noted that when Parliament made its motion accepting Jordan's Principle as a legal principle in 2007, that's when the clock started ticking with respect to those individuals who were eligible under the Jordan's Principle class. So essentially, that class would cover the period between December 12th, 2007 and November the 2nd, 2017. The tribunal also noted the effects of colonization in First Nations children and families, and how that residential schools, the 60 Scoop, and other forms of colonialization had impacted many parents. But the tribunal found that there were a number of parents that did not abuse their children. Therefore, they stated that parents who abused their children and those children were removed because of that abuse would be excluded from compensation. Next slide. So that was essentially the tribunal's orders. And as you can see, it had a very limited period of time where children and individuals would be eligible for compensation. And it had a problematic three-part test. So as a result of the various problems with respect to the Human Rights Tribunal order on compensation, the AFN filed its own class action relating to the discrimination to see if we can essentially provide more compensation to individuals and correct some of the deficiencies that occurred in the tribunal order. Next slide. So as I mentioned, there were a number of shortfalls with respect to the compensation order when it was issued by the Canadian Human Rights Tribunal. First of all, it was limited to $40,000 per individual. This $40,000 did not reflect the harm suffered by the individuals. It was limited to those individuals who were placed off reserve with non-family members. It also provided KIF placement, so I'll get into that in a couple of minutes. But essentially, where a child was placed into care by their parents with a friend or acquaintances, those children would be entitled to compensation regardless where they lived or where they were placed. And obviously, there was a problem with respect to the limited time frame where people would be entitled to compensation. Next slide. So this provides an illustration of how the Canadian Human Rights Tribunal order operated and how it was problematic. So say, for instance, a parent had 4 children and all 4 children were moved into care. The first child was placed in a foster home on reserve for 7 years. Under the tribunal order, that child that was placed on reserve would not be entitled to compensation because they remained in the community. The second child was placed in a foster home off reserve for 2 months. they would be entitled to a $40,000 compensation award because they were removed from their home, family, and community. So they met all three of those criteria. The third child was placed with an aunt off reserve for 3 years. They would not be entitled to compensation under the tribunal's orders as they were placed with a family member, so they did not meet the three-part test. And the fourth child uh, was placed off reserve and was placed in many foster homes over a period of 7 years. They would be entitled to compensation under the tribunal order of $40,000 because they were removed from their home, family, and community. As you can see, the tribunal order in many respects are unfair. Two of the children, one placed on reserve and one placed with a family member, would not be entitled to any compensation whatsoever. With respect to the child 2 and 4, you can see that both of them were placed off reserve in foster homes, but one was only placed for 2 months and they'd be entitled to $40,000. One spent 17 years in care and they would be only entitled to $40,000. So the tribunal's orders was very human rights focused, basically looked at the harm and compensated for the harm. It did not factor into any of the unique circumstances that any of the individuals would have encountered while placed in care. Next slide. So why did AFN file its class action? As I mentioned, we saw problems with the human rights order by the tribunal. So we wanted to ensure that there was a broader scope of compensation that would be made available. For instance, if someone was placed in the care in 2 months, they should receive less money than someone that spent 17, 18 years in care. That just makes sense. So we want to ensure that there was a proper quantum of damages to compensate the harms that were suffered by individuals on an individual by individual basis, as opposed to, a broad human rights lens. We want to correct the many deficiencies of the CHR decision, and we want to also expand eligibility. As I mentioned, the tribunal's orders only covered people beginning in 2006. Through the class action, we were able to expand the group of eligibility to those individuals who were apprehended between April 1st, 1991 to March 31st, 2022. Next slide. When we filed a class action and we began settlement negotiations, we also looked at past problems with settlement agreements. The AFN was also a signatory to the Indian Residential School Settlement Agreement. From that agreement, from the 60 Scoop agreement, the day schools, we saw many issues that came up through those agreements that were problematic. And we've basically took our experience from those different class actions to develop a different process for our class action. And essentially, we want to ensure that any burden placed on individuals was kept at a minimum. So with respect to filing of applications, it's going to be very little information that individual need to actually provide. So we're going to minimize the requirement for individuals to basically go out and gather supporting documentation and records on their lives to ensure that essentially the burden is kept to a minimum. And other class actions, such as the Indian Residential School Settlement Agreement, individuals had to file an application, provide all supporting documentation, medical records, all these sorts of things that was very burdensome on individuals, but also very triggering in many ways. And we wanted to stay away from that as much as possible under this class action. We also need to address progressive disclosure. And some of these settlement agreements that occurred in the past, essentially, once someone filed an application, that was it. They weren't able to amend it. If more information came forward or they found more documentation that would actually result in an increase of compensation, those individuals were not allowed to actually file any additional information. We wanted to ensure that under this class action, we can have a much more broader process. We will also want to ensure that we minimize any triggering of claimants in the application processes. we want to clarify the status of claimant records under the Indian Residential School Settlement Agreement, for instance. We had to go all the way through the Supreme Court of Canada to determine how the records would be retained, disposed of, or even destroyed. In the end, the Supreme Court of Canada, in that case, ruled that the claims forms belong to the individuals and they should be destroyed. By actually putting clauses in the current settlement agreement on child welfare, we're able to eliminate some of those issues. Next slide. So the final settlement agreement on compensation was negotiated over the last number of years, and it was approved in 2023. The agreement is fairly comprehensive, and it includes a number of provisions that deal with a number of classes. So essentially what we did is we used the Canadian Human Rights Tribunal order as a basis and to create the minimal standards in compensation. And we basically expanded upon many of those provisions. And it also addresses many of all the deficiencies that were included in the Canadian Human Rights Tribunal's orders, and we extended benefits to a larger group of people, going back to 1991. Next slide. So there are a number of classes that are covered under this settlement agreement, and keeping in mind that there are a number of programs that we're addressing. Obviously, we're addressing the First Nation Child and Family Services Program, which was the start of our litigation. It also incorporated Jordan's Principle. We also have the KIT class and the what we call the Trout class. The Trout class are Jordan's Principle-like cases that took place prior to Jordan's Principle actually becoming a legal principle in Canadian law. So the first class that we are able to deal with is the removed child class. These are children that were removed from their families and removed from their home and placed in care. Now, it doesn't matter where they were placed. They could be placed with a family member. They could be placed on reserve. They could be placed off reserve. They can be placed in a foster home. It doesn't matter where they're placed under the current settlement agreement. All individuals that were removed under the First Nation Child and Family Services Program between 1991 and 2022 would be entitled to compensation. They'll receive the base compensation that is available under the Canadian Human Rights Orders, Tribunal orders, but we're also going to develop a number of enhancements, and these haven't been developed yet or finalized, but we are looking at that. But essentially, individuals will be entitled to additional top-ups on top of the $40,000 base compensation. These will look at the individual circumstances of that child to make it more equitable. So, for instance, when the child was removed, were they removed as a baby or were they removed as a teenager would be one factor. How much time they were in care, was it 1 month, was it 18 years? That would have an impact on how much more compensation someone would be entitled to. Were they removed for an essential services? For instance, they had a disability that could not be provided by the family, and parents had no option but to place the child into care. That would be an extenuating circumstance where someone would be entitled to further compensation. Were they removed from a northern community, a remote community? How many times were they placed in care? Those types of things will be looked at. So we do have a budget of $7.25 billion to address discrimination from the removed child class. The next class is the removed child family class, and this is for the parents or the caregiving grandparents of the child at the first time of removal. Essentially, the way we look at this is if a child was basically living with grandmother and grandpa and they were removed and the parents weren't in the picture at that time, the grandparents would be entitled to compensation. If there was the parents that were taking care of the child at the first instance, the parents would be entitled to compensation. And we just wanted to ensure that whoever was taking care of the child when they were removed would be entitled to compensation. And again, they'd be entitled to $40,000 in compensation to a maximum of $80,000. So this really, the compensation that a parent would be entitled to is essentially for two children. So in that example I mentioned before, where a child with four children were removed from the parents would only receive a maximum of $80,000 in compensation. Basically, we have a budget of $5.75 billion for those individuals, plus an additional top up. And the reason why the family class is limited to individuals, it was consistent with the tribunal's orders on the parent class. Next slide. Next, we have the essential service class and the Jordan's principal class. So again, these two basically classes are essentially Jordan's principal-like classes. The essential services class are those individuals who suffered discrimination where a child needed services, whether it be medical services or services that help a disability, that type of thing, that occurred from December 12, 2007 to November 2nd, 2017. These are individuals, I shouldn't say, I can mix up. The essential services class and Jordan's principal class are pretty much the same thing. So the essential services class are those individuals who were denied medical services or some other type of services under Jordan's principle, but the services they required were not to the extreme. And I'll get into this in a couple seconds. But essentially, what the tribunal ordered with respect to Jordan's principal class, the tribunal basically said that those individuals who were denied a service or received a delay or a gap in services would be entitled to $40,000. But what the tribunal said is those individuals must have met the threshold of being the highest level of impact. And really, we don't know what that means. What is the highest level of impact? And again, you have to look at this compensation on an individual by individual basis. So somebody that may have been, for instance, at the highest level, someone like Jordan River Anderson, who had multiple needs, they would fall into the category of compensation where they'd be entitled to compensation as a Jordan's principal class. But somebody, for instance, that needed reading glasses and did not get those and may have, not done so well in school, they may not have reached the highest level of impact, but they did still suffer discrimination. So what we've done in the Jordan's Principal and Essential Services class is we want to ensure that everybody that has suffered discrimination should be entitled to some form of compensation. So for those individuals that met the highest level of impact as per the tribunal's orders would be entitled to base compensation of $40,000 with additional enhancements. For those individuals that did suffer some discrimination by Canada but did not meet that high threshold would be entitled to compensation under the settlement agreement up to amount of $40,000. We don't know what the amount will be. We don't know how many applications will be coming forward. So that's sort of how that operates. So essentially, we have a $3 billion budget for that. Next slide. So we have the Trout class, and these are individuals who suffered Jordan's principle-like discrimination prior to Jordan's principle being a legal principle in Canadian law and Canadian programming. So these are individuals who needed a medical services or another type of service for their child between 1991 and December 11th, 2007. And they would be entitled to compensation up to amount a base compensation of $20,000 plus additional enhancements. Now, the reason why this class is getting less money than others is because many of these individuals would be statute barred from receiving any compensation. So even if these individuals file their own class action at this point, uh, they would have not met the statute of limitations, as statute of limitations would have applied, and many of these individuals wouldn't be entitled to any compensation whatsoever. So we want to be fair to these individuals, and we want to ensure that those individuals would get some form of compensation. So that's the Trout class. The next category, of course, we have the Jordan's Principle and Trout family classes. So these are the parents, the caregiving grandparents of the child um, that needed essential services. And they would be entitled to uh, the Jordan's Principle family class would be entitled to compensation of $40,000 per the tribunal orders. The Trout family class will be that amount will be determined at a later date by the Settlement Implementation Committee. Next slide. So the last category we have is the KITH class. And this is the group that the tribunal ordered compensation for that was kind of a preferred class. So as I mentioned, if a child is removed by a child and family service agency, in order for them to get compensation under the tribunal's orders, they would have to be removed from their family, their home, family, and community. But for the KITH class, it didn't matter where they were placed, they'd be entitled to compensation. So we fixed that discrepancy with our class action, but we also need to include the KITH class in the class action itself as ordered by the tribunal. So the KITH class are basically those individuals who are, as a child, is removed from their home on reserve and placed with a KITH caregiver off reserve between April 1st, 1991 and March 31st, 2022. So essentially, a child welfare agency says we have concerns with respect to this child. They communicate to the parent, and the parent says, okay, I'm going to place my child with this family, a family friend, off reserve. And at that point, once they're placed off reserve voluntarily, the Child and Family Service Agency would no longer have any involvement. So those individuals would be entitled to compensation in the amount of $40,000. Now, it's important to note that a child welfare agency has to be involved in these cases. It's, for instance, if somebody was living on reserve and needed to attend high school for university entrance courses, and they moved off reserve and were placed with a family friend, those individuals would not be entitled to compensation because they were not removed under the First Nation Child Family Services program. As with the other classes, the KITH family class, so basically the caregiving parents or grandparents would be entitled to base compensation. And there may be some multiplication based on how many claims they would be approved. Now, with respect to the KITH class, we don't anticipate there'll be a lot of individuals. We note that the trend typically was a child would be placed off reserve voluntarily. They'd come back home, and at some point in the child's life, they would be removed by a child family service agency. So many of these KITH class members would be essentially fall into another category at some point in their lives. Next slide. So for the Assembly of First Nations, it was also important to ensure that other services were being provided to these individuals. So for instance, when the AFN argued for compensation originally, we basically wanted compensation to be paid to the siblings of the removed child, as well as the extended family. Because we know as First Nations people, once a child's removed from the family, the extended family suffers. So if a child is taken from the family, the brothers and sisters lose contact with that child, they're impacted. The aunts and uncles are also impacted. Unfortunately, the Canadian Human Rights Tribunal did not agree with the AFN in ordering compensation for those individuals. So what we developed is a CHRT fund, and this is a fund. It's not a lot of money, but essentially it's some form of funding that may be available to individuals who suffer discrimination that are outside the agreement. For instance, a sibling of the child, that type of thing. We also have the Caring Society also wanted a Jordan's Principle CHRT fund in the amount of $90 million. This is going to be administered by the First Nation Child and Family Caring Society themselves, but it's essentially another fund that we made available to individuals who have Jordan's Principle-like needs moving forward. The additional elements that we want to ensure that was incorporated in the settlement agreement, of course, is interest and surplus. So we want to ensure that those children that are covered under the tribunal orders will receive interest on the compensation they're entitled to as per the tribunal orders. But there are other individuals that are not covered under the tribunal orders that, again, it'll be a number of years by the time they actually get compensation. You also may have a child that's in care right now that may be 5 years old. We don't know how long they're going to be in care, but by the time they are entitled to compensation when they turn 18, a number of years would have passed. We want to ensure that the $40,000 that are eligible for today will not diminish, and it would equal what it would be equivalent to $40,000 in the future with interest and other enhancements. So basically, we're talking about buying power. We want to ensure that $40,000 that they're entitled to now would be reflected in an additional amount later on. So it covers things such as inflation, those types of things. And we've also developed a number of top-ups and enhancements that have yet to be determined. But again, this will look at the individuals from and provide compensation on an individual basis. For instance, as I mentioned, you may have a child that was removed from their family at the age of 2 years old. They may have been placed in care for 16 years. They may have been placed in multiple foster homes. The original placement may have been a result of an unmet medical need. All those factors will be taken into account in determining how much more additional compensation that individual will be entitled to above and beyond the $40,000 that as far as the base payment. Next slide. In looking at past settlement agreements, we also want to ensure that we provide as many supports and help to individual claimants as much as possible. As I mentioned, another settlement agreement, in order for somebody to apply for compensation, they would have to fill out an application form. They would have to acquire medical records, other records to basically prove that they were entitled to compensation. Our process is going to be different. So as some of you may know, the administrator of the class action does have the names, birth dates, status numbers of all those individuals who were apprehended by Canada, under the First Nation Child and Family Services program. So we have a lot of information on those individuals. So essentially, under our process, the very first form that somebody will need to send in would be very basic. Basically state their name, their birth date, maybe some banking information, and that's basically it. That'll go to the administrator. The administrator would run the name, the status number, and birth date against the database that they have. And if there's a match, they'll automatically be entitled to $40,000 in compensation. A claim form would be prepared, and there would be claims helpers that would be made available to those individuals. For instance, once the administrator says, yes, there's a match, here's the information that we have, there may be some errors with it. For instance, it may see someone was placed in care for 6 years when they were really placed in care for 8 years. So the claims helpers would be able to work with those claimants to ensure that the application is correct. And they'll also be able to provide various assistance to those individuals applying for compensation. The long and short is that claimants themselves will not be left alone for them to basically fill out the application themselves. The burden is mainly on the administrator in that process, much different from other class actions. Secondly, we have a number of service coordinators. So when the claims helper is working with an individual, it may become apparent that they may need other services such as mental health supports, addiction supports, those types of things. The service coordinators will be able to work with various professionals, make referrals to individuals, to professionals for that child or for that young person, and ensure that if they do need some services, that will be made available to them. We're also ensuring that mental health addictions and health supports would be made available to individuals should they request them. Again, we want to ensure that those individuals who have to relive the experiences that they encountered in being removed do have the various supports to help them get through this process. There'll also be cultural supports and lastly, financial literacy supports. Now, we know that in other settlement agreements that once a child or an individual gets a big check, that sometimes some individuals had difficulty with handling such a large amount of cash. Financial literacy will be there to ensure that they have relevant information on maybe how to invest their funding, how to get a GIC, how to lock in their money so it grows over a period of time. And again, that's all complementary information and supports that be made available. None of these supports are compulsory, but they will be made available to those individuals who are interested in them. Next slide. So that's essentially the settlement agreement in itself and some of the genesis. It's been a long road getting here. And, one thing that we did push forward at the tribunal and at the federal court really deals with the various harms that individuals suffered. And one thing that we found at the tribunal level is that many of these individuals who were apprehended and placed into care was unnecessary. For instance, the perverse incentive in the program itself it basically ensured that a child and a family would not be entitled to any services at all unless a child was apprehended. That was completely different from the provincial agencies where the provinces provided all the services they could and removal was the last resort. For many First Nations people, removal was the only resort. And we found that through the evidence that roughly 95% of the children that were apprehended didn't necessarily need to be apprehended if there were prevention programs available for those individuals. Those prevention services most likely would have been able to ensure that the child remained in the home with their loving parents. And that was the most disheartening aspect of the evidence that was put forward before the Canadian Human Rights Tribunal. The fact that you have loving parents who are doing their best for their children, and in the end, because of some shortfalls, their children were taken from them. And had prevention programs, had funding been available to child welfare agencies to actually provide prevention services or least disruptive measure services, many of those children would have never entered into the system to begin with. So through other work that we're doing on long-term reform, we're trying to address those things as well. But that was really disheartening in the evidence, and that's why the tribunal agreed with the AFN that compensation needed to be paid, because Canada could have provided that funding, but didn't. And Canada now acknowledges what they did was wrong, and which is why they've entertained the settlement agreement and entered into that with the Assembly of First Nations. And we're quite happy with the result, and compensation would be starting to roll out or become available to individuals starting March 10th, and basically in a month, less than a month from now. So that's essentially where we are and how the settlement agreement came to be.
We really appreciate this conversation, Stuart. It's important when we started this to know where we began and what we're talking about because there's lots of misinformation. There's lots of people, perhaps, the language can be confusing and understanding of when we talk about removed child and KIF class and Jordan's principle, what did that include? So thank you again for your time. We appreciate your expertise and your contribution to this. Um, Recordings again will be of each webinar. I know there was a question just generally, where will this be available? It will be at the website, and the website is listed there under the, general, you can find it under First Nations childclaims.ca. As a reminder for everyone, just as you listen over the next few days, to remind to take care of yourself, to remind that some of the information, even talking about it, can invoke feelings of, in terms of trauma, can invoke feelings of not feeling well or what had happened to us or family members. And to know that there are mental health supports available 24 hours a day through Hope for Wellness. They're open even on the weekends, and 3 o'clock in the morning or 11 o'clock at night, they are there. We thank you again for your time today. Your presence was felt, and your just listening. As we listen, we always say when we listen, we learn. And when we learn, we can contribute more in giving back to our community. So thank you for your time. Masicho, miigwech, hi hi. And in my cultural language, we never say thank you. We just say hand to heart. And I thank you all for being here. We'll leave this on the page again, just for general information. Again, you can call our number 1-833-852-0755, and that's Monday to Friday from 8 a.m. to 8 p.m. Eastern Standard Time. Thank you again, everyone, for your time, and we look forward to our second conversation tomorrow, part 2, for those who are registered. And if you've not registered, there's still time to do that. Thank you again, everyone, for your time. Have a great day.